Hi, everyone. I'm Oriana Senatore, a Senior Vice President at the U.S. Chamber Institute for Legal Reform, and welcome to another episode of Cause for Action. This episode is all about food, or more specifically, lawsuits targeting how companies communicate about food. ILR first looked at this issue back in 2017 in a paper we called The Food Court: Trends in Food and Beverage Class Action Litigation. Basically, we found that starting in the late 2000s, there was a major spike in class action lawsuits over product labels and marketing. One of my favorites was a lawsuit against Starbucks, claiming their cup sizes for iced coffee were deceptive because the cups had ice in them, not just coffee. But a lot has happened since 2017, so we asked Cary Silverman of Shook Hardy to put together an update of the food court research, which you can now find on the ILR website. I won't steal Cary's thunder, but I will say those trends we saw in 2017 aren't slowing down. So here to tell us more about these lawsuits and what's driving them, I'm happy to welcome Cary Silverman. Cary's a partner at Shook Hardy, where he manages a broad portfolio of public policy work and litigation in product liability, tort and consumer law, and civil justice reform. And of course, in his spare time, he authors outstanding research papers for ILR. Thanks for being with us, Cary.
Thanks for having me, Oriana. Thanks to you and to ILR for working with us on this paper.
Always happy to. So let's kick things off. Can you give us a flavor for this litigation? What types of food lawsuits are courts seeing, and what is driving this increase?
Well, a flavor is exactly the right word, because that's the type of lawsuits that we're seeing most recently. Lawsuits that are concentrating on the flavoring or the ingredients of products seem to be, as one might say, the flavor of the month for this type of litigation. We've seen if in our 2017 paper, there were certain types of lawsuits like slack fill that were sort of the rage a couple of years ago. And while those have fallen to the wayside for various reasons, the new flavor of the month are the flavor lawsuits. We're seeing, any product that is has flavoring or that is advertised as, having with a maybe a fruit picture or is vanilla is subject to a lawsuit. And we're also seeing lawsuits that are just targeting the ingredients and of food products. Any product that is labeled as sort of made with a certain ingredient, made with whole grain, made with real cocoa, made with real ginger. Those types of products are being targeted for lawsuits. Even cookies that are striped with fudge, keep fudge cookies, for example. We're seeing lawsuits targeting that kind of product. Is it really fudge? Does it have enough sugar? Does it have milk? Does it have enough butter to be fudge? Do graham crackers have enough honey? Do they have enough graham flours to be graham crackers? And even white Kit Kats and Reese's Whites, do those need to be made out of white chocolate, or are consumers being deceived otherwise?
Well, aside from making me hungry, it seems like these lawsuits are all about the yummy stuff. So that's the what. Let's talk about the where. Why do these keep popping up in California and New York?
Yeah, California and New York. I mean, it's amazing to see that about 3/4 of the nation's food litigation is in just 2 states, mostly in the federal courts in those states, some in state courts, but mostly federal courts. And why is it? I think there are 3 factors why those states are the biggies, and they are: number one, that's where the lawyers that tend to bring these claims are practicing. That's their sort of home turf, and that's where they bring the suits. I think that's the primary driver. Number 2 is the consumer protection laws in those states are very plaintiff friendly. They allow for attorneys to collect their attorney's fees. In New York, they allow for statutory damages, which means that even if They can't show that consumers actually had any significant or any loss at all. They can ask for a certain amount of money anyway. They don't have to show a loss as minimum damages allowed. Um, and the laws may not require basic things like showing that a consumer actually relied on an advertisement or a marketing practice when buying the product or that those are the types of things that you know I think drives litigation to those states. And then the third is just simply that they're very large states. That lends itself to larger class actions, more consumers that can be part of the claim, and that means higher demands for settlements.
Yeah, that does make a lot of sense. I mean, California and New York do come up quite a bit when we're talking about states with bad legal climates. Okay, so let's talk about tactics a little bit. Why do businesses decide to settle these claims instead of fighting them in court? I mean, some of them are just so ridiculous. Doesn't that just signal to consumers that the business did something wrong?
Yeah, I think businesses, they just do the math. It's not a signal that the business did anything wrong when they're hit with these suits. These suits can be filed very quickly with minimal money. A lot of these suits are basically cut and paste complaints where the plaintiff's lawyer can simply swap in the name of the next product, the next company that makes a similar product. If you're filing lawsuits against products that are flavored vanilla, there's a lot of products you can file lawsuits about, whether it's ice cream or yogurt or what have you, and claim that consumers in each of these cases think that it's got to be flavored with pure vanilla bean or else they're misled. And so it's very easy to just go to the next product on the supermarket shelf and file the claim. It doesn't necessarily mean that there's anything that a business did wrong. Sometimes lawyers will look for good plaintiffs lawyers will look for some minor technical issue with a label. There's all kinds of regs for labeling, particularly, for example, with flavoring. If you don't put on the front with natural flavors or with other artificial and natural flavors, or it's on the back but it's not on the front, it's the font size is too small, those open the business to a claim that there's been some violation of a regulation. And while there's no private right of action to sue about those types of things, and it doesn't necessarily mean some minor thing like that is going to mislead consumers, it does open the doors, and plaintiff lawyers will grasp it as a way to try to get their suit moving and sort of pressure a company into a settlement because there's something that they didn't do 100% right on their label. So that, but it really doesn't matter. I mean, you'll see lawsuits where there's no issue with the label at all, and maybe the complaint says there is, and they're just sort of filed without a whole lot of factual investigation. Without they're just sort of a mill of complaints. So there's not a lot that goes into filing the lawsuits, and it doesn't mean a business did anything wrong. So why do the companies settle them? I think it's a real valid question. It really just comes down to businesses doing the math about, okay, what is it going to take for us to get this complaint dismissed? And what are the risks that it won't be dismissed? And if it's not dismissed early, at an early stage, what does that mean for us? Well, that means we're going to move into discovery, which will mean we have to produce some sensitive business records. We have to produce our executives and staff members for depositions. And if it keeps going through that stage of discovery and you get to a point where there's class certification, well, now you've moved from a lawsuit that was involving one individual to one that is representing everyone in the state, or multiple states, or the entire country. So if a class is certified, the stakes go way, way higher. It goes from being maybe a case that could have been settled for $30,000 or $50,000 to one that you're talking, 500,000 or over $1 million to settle. So all those risks get taken into account, and it gets businesses know, and they've seen, even the most ridiculous of cases, there's sort of a 50-50 chance, maybe a little less, depending on how crazy the lawsuit is, that it's going to, get past a motion to dismiss. And the reason for that is at that early stage of the litigation, questions of fact are determined in favor of the plaintiff. All sort of benefit of the doubt is given to the plaintiff. And even though, most consumer protection laws say that a complaint, has to be, show that a reasonable consumer would be misled by whatever the marketing practice is. And that ought to be determined objectively as it is in tort law. But what happens is there are a lot of courts that will say that's just a question of fact. I can't determine this at such an early stage. We're going to have some discovery about it, and throw in some of these cases some minor technical issue. And a lot of these cases make it past that stage. And if they do, then we're talking big bucks. And so, a lot of the companies will say, let's settle this as quickly as we can. Why burn money on our lawyers spending on a motion to dismiss, and then, the risk of discovery and then class action certification, if we could get this resolved now for what may be less than the cost of even filing a motion to dismiss. And that's what often happens. You see in about 2/3 of these cases, maybe they disappear in about 3 to 6 months, and the docket will just say dismissed with prejudice per stipulation of the parties, or voluntarily dismissed. And most of the time, what that indicates is a private individual settlement where the lawyer gets paid, the plaintiff's lawyer gets paid, and the class representative, the person whose name the suit is brought on behalf of the individual plaintiff, gets some money out of that settlement, but consumers get nothing at all.
Yeah, that's a lot of pressure on a company, a really tough calculus, but a great business model for the plaintiff's lawyers. So tell us what's fresh, what's going on. The paper talks about some other new trends in food litigation, like greenwashing lawsuits. What are those, and what are some of the other types of new litigation that you've seen?
Greenwashing lawsuits is a new trend. I think our paper talks about 3 really significant new trends. The greenwashing lawsuits are lawsuits that are challenging products, or they're targeting companies that market themselves as environmentally responsible or as animal friendly. Look, no one wants to go out and purchase a product and be deceived into thinking this is a green product and buy it and find out that it's not. But I think what you're seeing in a lot of these cases, it's that the good guys are the ones that are getting hit with the lawsuits. The ones that go out on a limb and they put a statement of their principles on their website about what they're doing to make their products better, to make the earth better, and we're going to establish these special programs, and we're going to go to good farmers, and we're going to make sure we're treating our animals the best that we can. Those companies are the ones that expose themselves to the litigation. The ones that don't say anything, the ones that stay quiet and aren't doing anything, those are the companies that are insulated from the suits. So, that's what we're seeing there. The statements are taken out of context on a company's website, sort of cherry picked, put into a complaint, and then the plaintiffs will say, which is sometimes an individual, sometimes an organization with its own sort of special interest, will say that the company didn't live up to its own standards for X, Y, or Z reasons, which we think it should do. And so that's the kind of case that's getting litigated there, the greenwashing suits. And it's not only food that gets hit with these types of lawsuits, food products. You see them also with respect to all kinds of other products as well, but we're certainly seeing more of them in the food realm. A second trend that I think that we're seeing uh, is even a more a rise in claims, lawsuits that stem from testing products for chemicals or other substances. And the primary targets of these suits, are products that are advertised as pure, as 100% something, as natural. But you also see them in products that aren't, advertised that way, just on the basis that they're advertised or marketed as just generally safe products, but they have X of them. And what happens is the lawyers will hire a lab, their own lab, or sometimes they don't even. They will, go off third party tests that might be reported by some advocacy group, and they'll say that there is this minuscule percentage, parts per trillion of something that was detected in a product. We've seen it with respect to glyphosate. This is an herbicide that is the most widely used in the world. It's everywhere. It's been approved in the U.S. for decades. It's generally understood as safe at the types of levels that are being claimed or are found in these products, assuming that the tests are even accurate. So there have been lawsuits alleging that there's glyphosate in impure honey, which comes from the bees, by the way, that are pollinating the flowers, from in ice cream, in oatmeal, all kinds of products. We've seen similar suits more recently targeting baby food. Nobody wants bad things in their baby food, understandably. And we're seeing claims now that there are traces of heavy metals in baby foods. We're seeing also some suits targeting mac and cheese, of all things, saying that there's phthalates, I hope I'm saying that correctly, in the mac and cheese, which at trace levels, and that's something that apparently happens as part of the manufacturing process, just going through being put together. It's in all kinds of cheeses, and it's at minute levels. It doesn't pose any risk, but you don't want anything like that, and nobody wants to hear that there's anything that shouldn't be in their food. And so it raises, alarm of consumers. But we're talking here again at levels that are safe, that are minuscule, that are barely detectable, if they are detectable, background levels that you find in the environment. And so that's another trend that we're seeing there. I think we'll see more of those kinds of claims. And the third kind of, I think, brings in those first two, which is that in the District of Columbia, there's a unique law that allows individuals, and it allows advocacy groups, nonprofit organizations, public interest organizations, to file consumer protection lawsuits. They could file them on their own behalf, on behalf of their members. They don't actually have to have an individual client. They don't have to have an actual consumer who lives in the District of Columbia that actually purchased a product and claims they were misled by something. They can just sue under this District of Columbia law as a private attorney general. And so we're seeing more use of that law to bring both the greenwashing types of claims and the testing types of claims.
Great, thanks. So that's a lot about the sort of upward trends, what's new. We talked quite a bit in our 2017 paper about the slack fill lawsuits, but you found that kind of litigation is actually trending downwards. Is there a reason for that? Can you explain it at all?
Yeah, it's really fallen off. And when we looked at it a few years ago, leading up to that 2017 report, there were certain firms that were in New York, in Missouri, in California, that were filing these by the dozen a day. Amazing. It was probably more than 10% of all food class action litigation. They've completely fallen off. They were targeting things like the number of gummy bears in a box, and Swedish fish, and even the amount of iced coffee in a bottle, eh, rice, the number of rice kernels in a box. I mean, all these crazy kinds of claims, and they were alleging that you know consumers would simply think, based on the size of the container, the box, the jar, whatever it was, that it would be filled to the brim, and there would be no space inside. And regardless of the amount of ounces printed right on the front, the serving size printed on the back, and in some cases even the number of items inside printed on the label itself, that they would just look and think the biggest one has the most amount of food in it, or drink in it, and so that's the one they would buy, and they were being ripped off. Courts eventually saw through that, and gave more credit, I think, to consumers than plaintiffs' lawyers give them. They understand, they see, the amount of ounces that it's on there, and they weren't being deceived. And some of these complaints were just over the top. They'd manipulate photos and make it look like there was room in the box when there wasn't. There's all kinds of reasons why there's an empty space, legitimate reasons in a container, whether it's just plain old settling, or whether it's the packaging needs of actually having to put the product in the container. There's legitimate reasons for it, and those are just being ignored in these types of lawsuits too. So you saw a whole number of cases dismissing these slackville claims, and I think the flavor of the month eventually ended there. You see very few of them today. We found like two in the last couple of years that have been filed. There may be more out there, but certainly not being brought anywhere near the rate that we were seeing them before. And it is what we see with a lot of the food litigation. There are those claims that suddenly pick up a lot of speed because certain plaintiffs' lawyers start filing them and generating cut and paste complaints, and copycats in other jurisdictions will pick up and do the same thing where they are. And then just as suddenly as they pop up, they will leave. And I think we're starting to see that now with the vanilla lawsuits already in New York, especially. Enough judges have dismissed these cases where they're starting to go to other jurisdictions, and they're starting to stop in New York, or maybe move and look at other flavors to attack.
Well, the good news there, I guess, is that the courts were getting it right for the most part. But for all this other stuff we've been talking about, it sounds pretty messy. Are we just in the soup here? Or is there something that legislators or courts can do to address these other types of lawsuits that we're seeing?
Yeah, judges really have a big role here. And I think what food companies would hope for, and what's good for the public interest, is to have courts look at these cases with the eye of reasonable consumer. I mean, reasonable consumers are not going into a store buying a flavored seltzer that has orange on the front with a picture of an orange and thinking that it's made out of fruit juice. Reasonable consumers are going, and they're not buying fudge striped chips looking for the pure fudge you would buy in a specialty store. They're looking for a cookie. They're not buying lemon biscotti for the amount of lemon juice in it, or chips with a hint of lime juice because they expect a lot of lime juice in their chips. And they're not buying diet soda, and this is one of the some of the cases we found in our paper at the appellate level. They're not buying diet soda because they think they're going to buy it as a diet product to lose weight. They understand that the soda's marketed that way because it means it doesn't have sugar. It has something else. And so consumers understand these things, and courts should too. They should apply the same reasonable consumer test as if you talked about these suits to a person on the street and they would say, come on, we don't think that. We didn't buy it for that reason. And if courts just simply did that at the motion to dismiss stage more often, rather than allowing these suits to proceed. And we do see a lot of courts make the right decisions. But for everyone that does the right thing, you do see some cases where you're scratching your head. I just saw one in one of these Seltzer cases that I mentioned, where the motion to dismiss is denied. And now that case is going to have to settle. And the more these cases go on past that stage, the incentive will continue to be there to bring them, and the businesses will feel pressure to settle them as early as possible. And as long as that cycle continues, the litigation will continue. Now, legislatures can get involved too, and we talk about that in the paper. We've seen in Missouri, for example, a good law passed that was needed to counteract some of the court decisions there that had said that, pretty much you can never get rid of these cases at the motion to dismiss stage, no matter how wacky it is. It's always a question of fact as to whether a reasonable consumer would be misled. And so that was a problem. And so the legislature came in and they put in place a law that said, no, the judge should look at this from the objective, reasonable consumer point of view, and can, in some instances where it's warranted, dismiss these cases. Among other, there were other provisions in that law as well that are helpful about actual damages, for example. But that's an example of how a legislature can get involved. There are other things they can do. Arkansas enacted a law that, like several other states, said, we're going to allow individual lawsuits if someone was misled by a product to bring a claim under our consumer protection law. We're to make sure the state attorney general can always enforce the law. And you never see any of these kinds of cases from state attorney generals because they don't believe consumers are being misled in any of these cases. They'd never bring these types of claims, but they can, and they don't. But if there was a situation where consumers were truly being ripped off, you see state attorney generals involved. And the Arkansas law continues to allow that. But what it says is we're not going to have these types of class actions anymore. And there are several other states that don't allow them too. So those are the types of things that can be done, among others, by legislatures.
Great, thank you. Yeah, that sounds like a great model. Hopefully others will take some advice from the states and the courts that are tamping down on this. So finally, let's end on a bit of a light note. I know you've seen a lot, but which ridiculous food-related lawsuit example is your favorite?
It's a tough one, Oriana. I think the ones that get me are I'd say, sort of a genre of lawsuit that goes after snack foods, like clearly tasty treats, and claims that consumers bought them for their nutritional, healthy qualities. I'll give you a couple of examples rather, because I can't just go with one. I mean, the one that really got me when we did the 2017 report was that there was a lawsuit against Krispy Kreme claiming that consumers, when they went to the counter and they pointed at the donut that said raspberry, that they thought they were getting real fruit filling in their raspberry donuts. And because they were not getting real raspberry, they were being deprived of the cancer-fighting benefits of those raspberries. That survived the motion to dismiss, and I believe it actually settled and inspired copycat lawsuits. So that's one example. Today's version of that, in this report, there are lawsuits alleging that 7-Eleven's Yum-Yuns, these onion ring type snacks, they're not made out of fresh onions. They have a little onion powder. They have other ingredients and flavorings in them. And, the consumers that are buying these are being deprived of the benefits of those vegetables. And my other, favorite is the lawsuits against Hostess that claim that their mini donuts, carrot cake flavored mini donuts, did not have actual pure carrots in them. And actually, the complaint, one that I've seen, there are actually more than one, goes through the history of carrot cake from medieval times and talks about the health benefits of carrots. So, I mean, these are real, and you see them in the courts, and I think anyone on the street would think they're just unbelievable.
Yeah, well, thanks for, I try not to laugh, but those are some great, crazy examples. So thanks for sharing. And thank you again so much for joining us, Cary. It's always a pleasure. To our listeners, I hope this was informative and didn't leave too bad a taste in your mouth. You can find our new food court paper and other resources on our website at instituteforlegalreform.com. See you next time.